Hey guys, Attorney Tim Anderson. Today's February 12th, 2020. Getting ready to walk into court. But you've been emailing me, texting me, sending me messages on Facebook about what the court remedies are going to be for House Bill 961. So I need to give it to you straight and tell you what we can really expect. So first off, most importantly, let's take a close look at how the federal courts work in the United States. In Virginia, we're in something called the Fourth Circuit, right? Which that means that the Court of Appeals for the Fourth Circuit, which encompasses Maryland, Virginia, North Carolina, South Carolina, what that basically means is that the United States is broken into different circuits. You know, we've all heard about the Ninth Circuit, like out in California. We're in the Fourth Circuit, all right? So you file a lawsuit in the district court, federal district court, and then it gets appealed to the Fourth Circuit, and then it gets appealed to the Supreme Court. That's how the system works on the federal side. So basically what we're talking about in Virginia is what is the law regarding assault weapons, the assault weapon bans, high-capacity magazine bans, things like that. All right, so here's what happened. About 4 years ago, Maryland passed their, the young lady walked by. Maryland passed the assault weapons ban in their state, and it looks very, very similar to Virginia. So basically they said you're not going to be allowed to purchase assault weapons. You can keep your assault weapons. And again, I'm saying assault weapons like they're saying them. I'm not calling them assault weapons. I'm just saying them like they're saying them. So please don't think that I'm calling things assault weapons. I'm just saying what the states are doing it, what the courts are calling them. So they said they put an assault weapons ban in place. You can keep them. You're not going to lose them. And they also put a high-capacity magazine ban in place in Maryland. Well, it got challenged. That case is called Kolbe versus Hogan. Now, the Kolbe versus Hogan went through the district court in Maryland. It came to the Fourth Circuit. The Fourth Circuit initially sided with the petitioners, basically saying it was unconstitutional. And then it was reheard by the entire court. 2017, Kolbe versus Hogan said 5 words, and I put them here on the Facebook. They stepped away from Heller and they said most common use in military service. Okay, those are the 5 words that changed the Second Amendment forever in the Fourth Circuit. They held that any kind of an assault weapon, which would be like a semi-automatic rifle and some of the other like pistols weighing more than 50 ounces and all this stuff that they're talking about, which is identical with what Virginia is going to do with House Bill 961. They said all those are most common in use in military service. Their lethality is more than a regular type of a firearm, so therefore it doesn't fall under the common use exception of Heller. Said the same thing about magazines. So the Fourth Circuit Court of Appeals has said that a 10-round high-capacity magazine ban is 100% constitutionally legal, that an assault weapons ban that just bans purchasing, which is what, purchasing and transferring, which is what Virginia's is going to look like now, is constitutionally legal. And the Supreme Court did not take that case. In 2014, the Supreme Court rejected an appeal about high-capacity magazines that came from California. So the only case that is in play right now is a case called Warman versus Healy, which comes from Massachusetts, which is a challenge about high-capacity magazines and whether AR-15s are in common use and all of that. Now, here's the deal. The Supreme Court has not agreed to hear that case. They took it in committee in January. They have not agreed to take the case. Now, they haven't said no either, but they haven't agreed to take the case. So as it stands today, Kolbe versus Hogan is the law in Virginia. And if House 9 Bill 61 passes and becomes law, there's not going to be a remedy in the courts. Nobody's going to be able to run to federal court and say that House Bill 961 is unconstitutional because Kolbe versus Hogan said that the Maryland assault weapons ban is constitutionally valid because it held that these types of weapons and high-capacity magazines are most common use in military service. Those 5 words change the game in the Fourth Circuit, and that is the law. Every district court in Virginia is bound to uphold that. They cannot go a different way. So if you file a lawsuit for an injunction or something like that in federal court, it has to be dismissed under the Kolbe versus Hogan case. It can be appealed to the Court of Appeals, but they're going to reject it because they've already addressed this. The bill is almost identical in almost every way and almost every word to what Maryland has done. So we are not going to have a backstop in the federal courts for this. Now, maybe we can argue in the state courts some things. There's not been a lot of that, but the state courts will be interpreting the Second Amendment consistently with how the Fourth Circuit has taken it, and I highly suspect that you'll see some mirroring of those decisions. So, having said that, this is a legislative fix. There's multiple ways that we're going to get relief from 961. The most important one is it doesn't pass, which is extremely important now. We're engaging the soft Democrats in the Senate to not pass 961. If 961 doesn't pass, okay, that's it. Game over. If 961 does pass, we are stuck with this until no earlier than 2024. Because what we have to do is we have to win the governor next year, we have to win the House next year, and then we have to go to 2023. We have to win and keep the House again in 2023, and then we have to win the Senate in 2023. So that means these laws would not change legislatively until 2024, July 1 of 2024. So we're not going to get good relief from the federal courts. The only other way this gets fixed, so 1, it doesn't get passed. 2, we re-elect Republicans back into office through 2 election cycles through 2024. And then 3, the only other way this gets fixed is this Warman versus Healy gets accepted by the Supreme Court of the United States. They take it, and then they rule that we are allowed to have high-capacity magazines and modern sporting rifles and all of those. Those are the fixes, guys. I'm telling you like it is. That's where we are with the law. So it is extremely important. We have 3 weeks now before the Senate's going to vote on 961. You've got to engage Lewis, Credees, Morrissey, Edwards. Those, we only need 2, and it looks like Lewis is on the side of the Second Amendment here. So we only need 1 more to come our way. So if you care about the ability of 961 to have a magazine that holds 15, or if you want to be able to pass your firearm down to your kid, or if you want to be able to continue to buy certain firearms, 961 has to die, and the only way it's going to die is if you get 2 senators in the Virginia Senate to vote no when it comes up. And that is ultimately, otherwise we're stuck with this until 2024, and that is if we win the governor next year, and that is if we win the House next year, and that is if we win the House in 2023, and that is if we win the Senate in 2023. So that's a lot of ifs for us to change this law legislatively. All right, guys, hope that helps. Have a good day.